Members, Happy New Year. I wish you all the best in 2024. I call to order the meeting. This is the Bills Committee on Waterworks Amendment Bill 2023. This is our third meeting. In the last meeting, we held a public hearing and a number of deputations came to express their views. We have a quorum. The meeting will start and we will make use of the request to speak button, so do not change your seat. Now may I invite the government officials to enter. This is our third meeting. Hopefully we can go into clause-by-clause scrutiny. I will invite the government to walk us through the replies that they have submitted. Members can put questions in relation to those documents. But I hope that after the first round of questioning on those documents, we can enter the clause-by-clause scrutiny. We have Director of Water Supplies and his colleagues, and we also have the Deputy Secretary from the Development Bureau. When you are ready, please brief us on the documents that you have submitted and the questions put in the previous meetings. Thank you, Chairman. Deputy Secretary. Let us first reply or respond to the views given by the deputations in the public hearing. There are a few types of public views. First, how should the landlords reclaim payments after passage of the bill? Well, landlords can only reimburse their water bills after receipt of the bills from the Water Services Department. Some members of the public are concerned about the overly lenient penalty. We mentioned that the first conviction, the offenders will be sentenced to a fine of level 3, and the excess amount of money should be repaid as ordered by a magistrate. As for the subsequent conviction, the offenders will be liable to a fine level 4 of fine. As for the enforcement power and targets, we mentioned that we want to enhance the enforcement power and efficiency, and we can obtain information from tenants and landlords. We will provide relevant information to landlords and tenants, and only if necessary will we require the landlords to provide relevant information. As for manpower, as mentioned, we have a team of 35 colleagues to work on the enforcement action, and we will also work with the RVD to handle relevant cases. As for sharing of information, Water Services Department and the RVD can share information with each other in relation to overcharging of water. Apart from RVD, we will collaborate with other departments and district councils to obtain relevant information from subdivided units household and conduct proactive patrol. There are some deputations who said that we should perhaps mandate the installation of water meters. We have already explained the difficulties, and if we mandate the installation of water meters, the landlords may transfer the cost of installation to the tenants. So we prefer the voluntary mode of the scheme. So that's our reply to the views expressed in the hearing. There were some follow-up actions that needed to be taken, including items A and items B as set out in the letter. As for item A, some members think that comparing to the crimes ordinance, the penalty of WWR in the new section 47B is too lenient. As we have explained, the proposed new section 47B in relation to provision of false or misleading information or document compared to false instrument related offenses under crimes ordinance, the coverage and the prosecution thresholds are different. Under Section 47B of the WWR, when there is misleading or false information stated, the offense will be substantiated. When we are setting the penalty, we want to achieve this proportionality-based approach. As for overcharging, it usually amounts to tens of hundreds of dollars. As for the past penalty that has been handed, it amounts to about $1,000 to $5,000, which are 10 times of the excess amount charged. After passage of the bill, landlords and tenants have to keep the receipts and issue a receipt to the tenants. Magistrates can ask the landlords to repay the excess amount charged to the tenants, and if they fail to retain the receipts, they will be charged another offense. As for Section 47C bracket 1, in relation to the definition of payee, is the agent of the payee and payee. Generally speaking, landlords will be the payee of water charges, and they should be held responsible under Section 47C bracket 1, so they should keep the receipts. Under certain circumstances, some people will receive or charge water charges on behalf of the landlords, for example, their friends or real estate agents. These people will be seen as payee and should be held responsible under the proposed Section 47C bracket 1. We will continue to do publicity to explain to relevant bodies about the responsibility under the bill. There are 3 members who have pressed the button, including Lam Chun Sing, Chen Xiu-hong, and Lai Tong Kok. 4 minutes per member, please. Mr. Lam. Thank you, Chairman. I would like to follow up on the reply given by the government about the WWR, that's 47B, and its difference with the crimes ordinance, Cap 200. Crimes ordinance is much more serious, which carries an imprisonment term of up to 14 years. As for 47B, we're talking about submitting false or misleading information or document. As for crimes ordinance, it relates to using a false instrument that causes prejudice against another person. So is there a scenario where both of the ordinances will be triggered and eventually that case or offenders were prosecuted under crimes ordinance? I would also like to ask about this. There are similar cases under other ordinances, for example, LTCO and the Airport Authority Ordinance and the Cats and Dogs Ordinance. There are similar arrangements. According to government's experience in prosecution, how many people were prosecuted or charged with these offenses? Will some of the offenders be charged with more serious offenses? I would like to know if some cases would involve a crimes ordinance instead of a WWR. Mr. Yao from the Water Services Department, please. Let me answer the first question. So under what circumstances will both of the ordinances be invoked? Say, if a person add an extra zero on the water bills to change it from $100 to $1,000 and charge $250 to each of their 4 subdivided unit tenants. Under such circumstances, that person would have come up with a false instrument apart from creating a misleading information. Under such circumstances, we will refer the case to the police, so the person will be charged under the crimes ordinance instead. Is there relevant cases under other ordinances? We don't see any of such in our records. Thank you. Next, Mr. Chan Siu-hong. Thank you. As for the government replies to the views expressed in the 12th December meeting, we are concerned about the definition of agent. The government said that the payee could be the agent, and that agent will be held liable under the newly proposed 47C bracket 1. But in government replies, it only sets that the reimbursement of water charges is involved. But what about receipts? If false information is set out in the receipts, would the agent be held liable? Because according to your wordings, I'm worried that agent would be held liable for the false information printed on the receipt as well. Perhaps in the clause-by-clause scrutiny, we can look further into that. I would like to follow up on the public hearing. Apart from the answers that you have given in your reply, there were other members, including myself and Mr. Lai Tong-kwok, that we hope that through a real estate agency or authority, some kind of monitoring can be done. Have you done anything? I would like to know about that. Thank you. Deputy Secretary? Thank you. The person who needs to issue and keep receipt is the payee instead of any agent who processed the payment. The person who processed the payment could be the agent of the payee. The agent is only transferring the payment. The agent is not the payee, and therefore the agent will not have to issue or keep the receipt. In section 47C bracket 1, we're talking about the payee who should keep the receipt or issue the receipt. Agent will not be creating any false instrument because they're only transferring the payment from the tenant to the landlord. We will conduct publicity and education and brief the real estate agencies about the ordinance. When they are aware of any false information printed on the receipt, they should notify their clients, and they should not get themselves involved. Let me supplement. Thank you, Mr. Chen and Mr. Lai, for making such suggestions that we should, instead of meeting with the estate agents authority, we should update the code of practice. Thank you for your suggestion. It is difficult for us to further define the words of payee and agents in the clause-by-clause scrutiny. Perhaps we can see how we can further clarify the words of payee and agent so that members of the public will understand more and to allay concerns.
Mr. Lai Tong-kwok, thank you, Chair. I'd like to write on the question raised by my colleagues about providing false or misleading information or documents it is suggested that a person commits an offense will be liable to an imprisonment term of 3 months. It's too lenient. If you compare the wording of the two relevant legislations, I think there are parts that are that duplicate each other. As mentioned, a lot of times you may have to refer the case to the police. Well, you're adding these provisions because you would like to handle the case yourself. Well, with the proposed provisions, problems arise. It looks like a person may be charged under the crimes ordinance as well. So are you going to handle such case within your own department, or are you going to refer it to another department? Well, I agree that it doesn't warrant the use of the crimes ordinance in every case. So you have come up with new penalties under your proposed amendments. You have provided 2 examples under the Waterworks Ordinance, Cap 102, Section 30. The maximum penalty is 2 years for offenses concerning pollution. For obstruction-related offenses, that is, say, if you obstruct an officer during his duty, penalty incurs as well. We want to prevent subdivided unit tenants from being overcharged for water. If during the investigation of the administration, someone knowingly or recklessly provide false or misleading information or documents, this amounts to obstructing a public officer from carrying out his duty. Therefore, I think the government should consider this. That is, whether you would consider increasing the penalty. We are scrutinizing a bill concerning wildlife animals in another bills committee. It is said that no one is allowed to feed pigeons, and for those who violate the rule, the person will be liable to a 6-month imprisonment. So I would like the government to think about whether it's possible to increase the penalty. You will be able to enhance the deterrent effect by making the penalty heavier. At the same time, you will deter people who think of from providing false or misleading information. And you can also make the legislation more effective. So that's my view. I'd like a response from the administration. Director, I thank Mr. Lai for the suggestion. If we look at the crimes ordinance, the maximum penalty for the relevant offense is 14 years. We look at the principle of proportionality and consistency when we consider the penalty. Say a person may pollute a water by dumping something into the reservoir. So a person who violates the relevant law will be liable to a level 5 fine and 2 years imprisonment. Also, people who obstruct officers from entering into waterworks facilities will also be liable to a level 4 fine and a 6-month imprisonment. For someone who provides false or misleading information or documents, well, we will propose a penalty of level 3 fine. We it is a relatively more lenient penalty, as we propose a level 3 fine and a 3-month imprisonment term, as we think that it is a less severe offense. Ms. Doreen Kong. As far as I understand, the administration comes up with 47B in its bill and introduces a new offense because it echoes the LTCO, the Landlord and Tenant Consolidation Ordinance. Overcharging for water is definitely not a right thing to do. For parts concerning SDUs under the LTCO, if you compare the provision with the current Waterworks ordinance, there is certain discrepancy. If you look at section 47B of the bill, well, there are similar provisions under the LTCO. I understand that it is inevitable that there are similar provisions in both ordinances. I hope the relevant departments and the DOJ, when they come up with penalties for new offenses in the future, they should really think about it carefully, how to do it. It looks like the penalty level for similar offenses differ or vary under different legislations. I understand that there are cases that may be passed to the police if it warrants the attention of the police. Problems arise then. As a member of the general public, I wonder if the administration will lay charge on me under the new section 47B or the crimes ordinance, because the penalty level proposed under the two legislations are different. This poses worries to the general public. If we want to make sure law and order, we have to ensure that there is stability. I hope the administration, when it comes up with penalty for new offenses in the future, it should consider the stability. There is a law principle known as double jeopardy, meaning that in one case we cannot lay charges on the same person twice. Say if we lay charge on a person based on section 47B, we cannot lay another charge on the same defendant under another legislation. This can become a defense of the person liable. So once you catch a person, you have to make it clear whether you are going to sue that person under section 47B or another ordinance. This is crucial. I thank Ms. Doreen Kong for the comment. When we came up with the penalty, we look at the relevant legislation. We make reference to the principle of relativity. That's how we came up with the proposed penalty level. But we will take into consideration Ms. Kong's comments as well. Mr. Andrew Lam. Say if there is a lack of water meter, then it is up to the landlord to negotiate with the different tenants how the bill should be apportioned among different tenants. Say there are disputes. What should we do? How do we define what is a false instrument? Let me give you an example. Say there are two households, one with a certain connection with the landlord and another without any connection with the landlord. And the aggregated sum charged by the landlord does not exceed that of the bill, then the landlord does not break any law. However, the landlord imposes the fee on a same household. Correct me if I'm wrong. Under the proposed bill, there is no way to deal with such dispute. You may have to go back to the LTCO to challenge the landlord who commits such acts. The Water Supplies Department claims that it will be responsible for handling such cases. However, under the scenario I mentioned, I wonder if you'll have to go back to the LTCO to deal with the disputes. I thank Mr. Andrew Lam for the questions. After the bill is passed, say 2 or 3 households are involved, and we look at whether the aggregated sum charged exceeds that of the bill. The bill is going to lower the chance of landlords overcharging his tenants for water. If there are no separate water meters in an SDU, well, as mentioned, under the LTCO, the landlord will have to show the bill or the relevant documents to the tenants. If, say, the landlord overcharges the tenants for, say, dozens of dollars, then the tenant would know based on the documents shown to them. If there are complaints, we will conduct investigation. As we investigate, we will look at whether the sum charged by the landlord is reasonable, and we'll also look at the water consumption of tenants to do a cross-check. Chair, we may be able to discuss it again when we come to the clause-by-clause scrutiny. I don't see any provision that can deal with the scenario I proposed just now. I don't see any provision governing landlord who overcharges tenants by imposing the aggregated sum onto one single household or one tenant. I want to know how the government is going to handle such situation. As mentioned, some of the cases may be handled by the police, some may be handled by your department. I wonder if you will go back to the LTCO as you enforce the law under these cases. Thank you. We've finished the first round of Q&A. As mentioned, we can have a more detailed discussion when we come to clause-by-clause examination. I understand that Mr. Lai Tong Kwok would like to pose some follow-up questions. Mr. Lai. Thank you, Chair. I want to follow up on the question asked by Mr. Andrew Lam. How are landlords going to make apportionment arrangements in an objective manner? How are landlords supposed to do it objectively? There are various ways that landlord can adopt. I think you should issue guidelines on how landlords should make apportionment arrangements. Should it be based on the floor area of a certain unit or the number of tenants in a, say, unit? I understand that you may not be able to include all these details in the legislation. However, if you have a guideline ready, it can minimize disputes. Say, for traffic issues, the police always refer to the manual issued by the transport department. I hope that you can provide written information to us on how you're going to deal with the various situations in the future. Also, can negotiations made between landlords and tenants be in written form or in verbal form? And can these agreements or so-called negotiations be accepted? We're mostly referring to two major parties, that is landlord and tenants. There may be disputes and complaints between these two parties. That's why we're discussing this bill here. If you can lay down all the details in your guidelines in the future, I believe you'll be able to reduce the chance of disputes between landlords and tenants. We can have a more detailed study on this when we come to the clause-by-clause scrutiny. I thank Mr. Lai for the suggestion. Like the road traffic manual of the Transport Department, there are many details included in the manual. In this context, say there may be 5 to 6 tenants in a unit, and in another household there is only one tenant. We have to consider all these factors when we decide whether the landlord is overcharging. Can we ask the landlord to install a water meter, for instance? We cannot include all these details in the bill. However, we can come up with a guide for the public so they know not to violate the rule. Thank you.
We've discussed much about the policy matters of the bill in the clause-by-clause scrutiny. We hope that the government officials will respond to the issues mentioned. We welcome the bill, but in terms of details of the bill and the penalty, some members have expressed their concern and views. And who should be enforcing the law under the two ordinances? I think that we should further discuss that as well. So we have finished with the discussion of the policy matters. Now we go into clause-by-clause scrutiny. Would the government officials please walk us through the clauses? The Legal Services Division has prepared a marked-up copy. Would anyone from the government please walk us through the ordinance or bill? There are 4 parts of the bill. The first part involves the introduction and the title. Clause 2 says that subject to Section 3, the ordinance will come into operation upon gazettal of the bill. Clause 3 says that Section 5 comes into operation on the expiry of 3 months beginning on the day on which this ordinance is published in the Gazette. And Clause 2 of Part 1 of the bill says that the enactments specified in Parts 2, 3, and 4 are amended as set out in those parts. Part 1, any question? Please proceed. Now I move on to Part 2 of the bill. This is to amend Waterworks Ordinance Cap 102. Members can refer to page 0001 to page 0002 of the marked up copy. Section 37 is amended. It says that Chief Executive in Council can provide regulations under the ordinance. So a technical amendment has to be done to include various provisions. That is, after section 37 bracket 1 bracket S, SA, SB, and SC will be included. Please refer to page 0002 of the marked up copy. Clause SA mentions the giving and keeping of copies of documents and the related charges paid to the person. SB says that the Water Authority's power to request any information or document for the purpose of this ordinance. SC concerns disclosure of information or document to other government departments. Now we move on to clause 3, bracket 2. It sets out the maximum penalty of the regulation, that is level 4. Well, the original penalty is level 3. That is why we have to make a technical amendment. The penalty will be raised to fine not exceeding level 4 and imprisonment not exceeding 3 months. And in the case of a continuing offense, by a further fine not exceeding $1,000 for each day during which the offense continues. There are 2 members who have pressed the button to speak. Mr. Lai Tong Kwok. I have a few questions. First, in the proposed amended 37 bracket SA, you set a person and you specify that person to be someone other than the Water Authority. In other words, according to the amended section 37, all Waterworks regulations, if you use this word a person, that person should not be the Water Authority. Otherwise, the scope would be too large. But in the amendment of regulations, in the subsequent clauses, you always refer to a person. So in terms of wordings, are you overriding the power casted upon you? Over the proposed amended section 37? Thank you for your question. In Cap 102 Waterworks Ordinance section 37, this is a empowerment provision. It says what the regulations regulate. The newly added paragraph SA corresponds to section 47 bracket C that is newly added about the keeping of receipts. If you refer to the newly added section 47C, it says that a person other than the Water Authority charges a specified user of an inside service for using water supplied through the inside service, then they should give a receipt to the specified user and keep the receipt. So the person mentioned here is the same. If we go back to clause 3 of the ordinance, the newly added paragraphs SB and SC, the power of the Water Authority is stated there. So if we look at clause 1 of section 37, that will correspond to other relevant clauses in the subsequent parts. So there will not be inconsistency in terms of the definition of a person in the bill. I have another question, Chair. In paragraph SC, You said to exercise a power, bracket including a right, bracket. Can you give us some examples as to what this power is or right is referring to? Ms. Ho, thank you for your question. This Section 37 is a empowerment provision. That is why the scope is larger or wider. The wordings is consistent with the proposed newly added Section 47A. As for power, in Cap 1 of the laws of Hong Kong, it defines what power means. But under the interpretation and general clauses ordinance, right is not defined. In some ordinances, it says that a public officer can request information from a person. When a public officer is empowered to do something, that is how it's expressed in the law. We don't say that the public officer has a right to do something. So when we were drafting the bill, we think that in order to avoid confusion of power and right, that's why we put the clauses in such a way. As right is not defined under Cap 1 interpretation and general clauses ordinance, that is why here we put including a right in the bracket after the word power. And in the same paragraph, we include functions, bracket including a duty. The corresponding provisions also exist in the LCSO, which is written in the same way. We always put power, bracket including a right, and function, bracket including a duty. Thank you. Mr. Andrew Lam. Thank you, Chairman. I would like to ask about SEP 37J and A. That is the charges payable under this ordinance, and K, the deposits to be paid by consumers. I understand that these two payments are different. Deposits are deposits. Charges are water charges. Because in the provisions in the later parts, it sets specified charges, but that does not include deposits. Let me take the question. In J, under Waterworks ordinance, there are a number of different charges and payments. And regulations on those payments can be set out in the regulation. And in the Waterworks ordinance, we set out what kind of charges is subject to deposits. For example, water charges would involve deposits. That is why these two are separately set out. So there is difference between these two payments, correct? If there is no further questions, please move on. Now I will move on to Part 3 of the amendment bill. This is to amend Waterworks Regulations Cap 102 Subsidiary Legislation A. Please refer to page 0003 of the marked up copy. We will make a technical amendment to Regulation 47 because the Section 2 of the Regulation 47 will be repealed and substituted with other paragraphs. As for the Clause 4 of the bill, it will be substituted by 47A. Please refer to page 0004 of the marked up copy. We set out the definition for selling or offering to sell. So if someone charges for a water that constitutes sale of water, in general tenancy and subdivided unit tenancy, that would involve sale of water and offering of sale of water.
The current ordinance does not only cover tenancy, but also cover other scenarios where water is used. To avoid any misunderstanding, we are including the definition of using water and offer for sale water. We are adding subsection 3 because we want to preserve the meaning included in the original ordinance. The Legal Service Division posed a question in written submission. That is the definition of using water and offer for sale water. The Development Bureau made a response. The current ordinance does not define the meaning of using water and offer for sale water. And for sale of water in SDU, it's covered under the current ordinance. And we are not only referring to the sale of water in SDUs, it covers other types of premises as well. So we're adding subsection 3 here because we want to preserve the meaning in the original ordinance as included in the Oxford Dictionary. We follow the definition of the dictionary as we refer to the meaning of sell and offer for sale. Say a boat may provide water from Waterworks to another boat for monetary reward, and this amounts to sale of water and it is regulated under the ordinance. We believe that the added subsection 3 makes it clear what it means by sell and offer for sale, and we do not think it necessary to provide extra definition for these two terms. Please refer to page 3 and 4 of the marked up copy in relation to the proposed regulation 47. For subsection 4, and 5, it provides for It provides that specified charges can be reimbursed by specified user of an inside service, and only a specified rate can be charged. Say, in an SDU context, each tenant should only pay a fee proportionate to the amount of water used. And questions were raised in relation to the rates to be charged, and the director has just given a reply about this, so I won't go into details here. For subsection 5, it covers scenarios under which exemption can be given by the water authority. It's the same as subsection 4. When there is offer for sale, the specified charges or specified rate will have to be used. The Electrical Secretariat, in relation to this part of the bill, posed a question. The response is that the landlord can only charge tenants for water after the bill is issued. Well, according to the reply of the Development Bureau, subsection 4 targets scenarios in which the bill is issued and the landlord receives reimbursement from his tenants. But this does not cover acts of offer for sale under subsection 3. That's why we are proposing to add subsection 5. For instance, a landlord designates a fee to be charged in the tenancy agreement, or before the bill is issued, the landlord is issuing an invoice to the tenant for water fees. This is not allowed under the law, and with subsection 5 added, we can ensure that the subsection 1 in relation to offer for sale of water will not be violated under Regulation 47. I see that some members have questions. Mr. Andrew Lam. Thank you, Chair. I asked questions about the definition. The administration is proposing to amend Regulation 47. There is a part about specified charges. Does that mean deposits cannot be charged by landlord? Well, in the past this is allowed because you exempt occupiers. Now, be it tenants of SDUs or not, does that mean landlords are not allowed to charge the tenants specified charges? Under the LTCO, there's a regulation. Apart from charges, what kind of fees can a landlord charge? For instance, rent deposits can be charged by landlord, and this is governed by the LTCO. Well, let's look at the two ordinances separately. Under the current ordinance, well, before the amendment, landlords are allowed to charge deposits. Well, now you are going back to the LTCO, which is a different ordinance. When Water Supplies Department asks users to pay a fee, we charge the user deposits. Well, I want to be more precise. WSD can charge users deposits, of course, and that's lawful. However, for landlords of SDUs and non-SDUs, well, what I understand is that landlords cannot charge the tenants deposits after the legislative amendment. After the amendment, landlords are not allowed to charge deposits. Under the Waterworks ordinance, landlords can only charge water fees for the amount of water tenants used. That's your legislative intent, right? That's very problematic. A lot of tenancy agreements will be affected after the legislative amendments. Is that your policy intent? I take issues with this. Well, let me supplement. On the point about deposits, we charge registered consumers deposits. That is 37J as mentioned by Mr. Andrew Lam. As for deposits charged by landlords under the tenancy agreements, this is not regulated by the Waterworks ordinance. As mentioned under LTCO, landlords can charge tenants deposits. As for utility services, landlords can only charge tenants the amount paid by landlords to public utility organizations. So this is not governed by this particular bill or ordinance. Let's say the bill is passed. You have the right to enforce the law based on the enacted bill. If a landlord charges a tenant deposits of the water meter, I'm not referring to SDUs. Say landlords charge tenants deposits for a water meter. Well, now you're telling me that after the legislative amendment, landlords are not allowed to charge this deposit. But let me answer this. Such deposit is another type of fee. Now, the Water Supplies Department only looks at whether the landlord overcharges his tenants for water and whether it would constitute illegal sale of water. So after the bill is passed, we look at whether landlords commit acts of sale of water or offer for sale water illegally. If landlord charges other types of fees other than water fees, this ordinance before and after amendment does not govern this. It falls under the remit of the LTCO. Sorry, I'm referring to subsections 1 and 2 of Regulation 47. It says clearly that the consumer of an inside service recovers the charges Sorry, I'll pause here. If you have no intent to make this part clearer, then it would be problematic. The legal advisor can provide some relevant information. Thank you, Chair. Under the LTCO, that is Cap 102AAL, it stipulates that only 4 types of fees can be charged, that is rent deposits, rent, and reimbursement in relation to utility charges, and compensation due to damages. And there is no stipulation that water fee can be charged by landlord even under the LTCO. Perhaps you can think about it after the meeting. This will have a far-reaching impact, this is my understanding. Does the administration wish to supplement? The major intent of this legislative amendment is to enhance the power of the Water Authority. We only intend to empower the Water Authority to gather more evidence, and we ask landlords to keep receipts.
Ms. Doreen Con. Thank you, Chairman. I have some other questions, but I would like to respond to Mr. Andrew Lam's question. I thank him for proposing or putting this question because I did not think about that myself, which is it is a very valid question. I am a real estate lawyer. In general residence and commercial units, say restaurants, it's common for landlords to charge tenants deposits for water charges. I understand why we are amending the ordinance. The intent is, of course, good, but after reading the entire Waterworks regulations and ordinance, that is Cap 102 and its sub-legislation A, in no parts of the law states that landlords can charge deposits from tenants. If that's the case, for all kinds of properties in Hong Kong, the charging of deposits for water charges will be in violation of the laws. I would like to thank Mr. Lam for putting this question. This is a very practical question. We may be able to help the subdivided units households, but that may harm the interest of landlords of other kinds of property. I concern about sub-regulation 4. It talks about proportionate portion. There is a definition for specified charges in the regulation, but what about proportionate portion of the specified charges? I hope that colleagues from DAG can explain about this. When we have to argue this point in the court, we have to specify very clearly what constitutes proportionate portion. Are we talking about the quality of the water or the size of the flat or units? Can DOG explain about this? Thank you, Chairman. Ms. Ho, please. Senior Government Counsel. Let me talk about this question relating to proportionate portion. We have not defined this proportionate portion in the laws because we need the legislation to be broad enough for enforcement to happen or to be initiated. This has been explained by the Water Supplies Department. So what does this proportionate portion mean? We refer to the definition of it in the dictionary. If we check the dictionary, we would know that proportionate means proportionately, and we connect proportionate portion with specified charges. In the newly added sub-regulation 4, we set out that after colon, proportionate portion of the specified charges for water used by the specified user in the premises. So the proportionate portion is about the specified charges for water used. So we have to look at sub-regulation 4 and 5 and 8 about the definition of specified charges and its relevant calculation. We think that this is a way to draft a bill to reflect the legislative intent. Chairman, I am not too clear about this. If there is installation of water charges, then such problem will not exist. So if you just say specified charges in relation to the amount of usage, no one knows. This proportionate portion does not only affect the landlords, but also the tenants. Tenants need to understand if the landlords are violating this regulation. But if they don't understand what proportionate portion means, then troubles will be arisen. You said that we have to be flexible in drafting of the laws, but we should not be this flexible. So how will you make use of this proportionate portion in real life? How should you explain this word's proportionate portion to the judge in court? Because we don't have a separate meter in subdivided units. Perhaps I explained about the subregulation. I would like to thank Ms. Khan for her input. Without a water meter, the water charges in subdivided units varies. As for this proportionate portion of specified charges, sometimes there is only one water bills involved in different subdivided units. As to how different SDU households use water, some people may shower 20 times a day. The water usage may be high in that particular SDU household, and some people may like to cook or make soup all day. So it's very difficult for us to set out all kinds of scenario in the laws. When this is the case, for reference of use of water, there could perhaps already been an agreement between the landlord and the tenants when they are signing the relevant agreement. They may, or the landlord may charge waters on the basis of how many people reside in the household or on the size of relevant SDUs. A tenant may work all day and some tenants may stay at home all day. They perhaps will have a reference in the agreement as to the apportionment of water bills. As mentioned, we will roll out a guidelines to clarify the apportionment arrangement. Let me supplement. For SDU without water meter, there could be variation in terms of use of waters among different SDU households. The tenants may be aware of the water charges charged to different households because of the returned requisite, but it's difficult for us to set everything out in the regulations. But we can understand this word proportionate portion in a general scope. Next, Mr. Lai Tong Kok. Thank you, Chairman. I will follow up on Ms. Khan's question. I have a suggestion. Let's see if this is feasible. When we are drafting the bill, I see sometimes the government would add examples, but that would not constitute part of the law. Some of you said that perhaps we will take into account the number of resident tenants in a SDU or the size of the SDU. Can you add, for example, an example under this subregulation? Of course, we cannot cover everything, but at least we need to let members of the public know what is the calculation basis and your policy intent. That's one way to do it. And perhaps you can create manual or handbooks on these regulations. To resolve the confusions that the public may have. I think that there is a way to solve this problem. Mr. Andrew Lam put another question. Section 47 regulates the sale and offer for sale of water. As for deposits, that is not related to the sale of water. Some landlords may need to charge deposits because they are afraid of default of payment from tenants. I think that deposits is not covered in the amendment bill. You do not prohibit the charging of deposits neither do you empower landlords to charge deposits. As mentioned in the LTCO, it sets out what charges landlords can charge their tenants. If we prohibit landlords from charging the water charges deposit from tenants, then they are not allowed to do so. If that is not set out, then there perhaps could be a gray area. Let me put my question. I have some questions regarding some of the words. In the English rendition of the bill, a person appears. This word, a person, appears. And in the Chinese rendition, you said someone. But in subregulation 3 and 5, you said anyone. So in English, a person means someone and anyone in the Chinese text. Can you align the wordings? Otherwise, there could be disputes because you are referring to the same thing with different words. I don't have any views in relation to the use of someone or anyone in the Chinese text, but I think that you should align them. My second view in relation to subregulation 2, you state in the English version that, well, the words using of water or for using the water, I think that you are referring to the use of water through inside surface. I think that you should clarify it. Change using the water from inside surface, because in subregulation 3, 4, and 5, you are referring to the same thing. I think that it will be more clarified if you add the words from an inside surface after for using the water. For subregulation 4 and 5, I think that the order is wrong. For subregulation 4, you state that the water charges can only be reimbursed after a water bill is issued. But for subregulation 5, you are talking about requesting a specified user to pay. But I think that you should request before receiving payment. So I think that you should change the order of subregulation 4 and 5. Landlords should be requesting for payment first before they receive a payment. If we change the order of subregulation 4 and 5, I think that would be smoother. Director, please. Thank you for your question. We will discuss with DOJ about the clauses. We will be formulating some handbooks or manual. As for 47 bracket 4, we're talking about specified charges. That's defined in the next part. That's in relation to water used in any premises means charges for the water calculated at a rate not exceeding the specified rate for the premises. That means water charges. But as for deposit, we have not dealt with it in the amendment bill. Next, Mr. Chen Xiuhong. Thank you, Chairman. I have two questions. First, about deposits of water charges. I agree with what Mr. Lai said. We are not to amend other parts of the Waterworks ordinance, including the deposits. And we have not set out under LTCO whether landlords is allowed or prohibited from charging deposits from tenants in terms of water charges. So we should not continue to discuss this issue, perhaps. But as this is a related issue, perhaps the government should look into that. under the LTCO. The DOJ colleague mentioned that under LTCO, landlords are not prohibited from charging deposits from tenants. Under such circumstances, or some circumstances, tenants do not fulfill their responsibility of payment, then the landlords can recover their charges by deducting from the deposits. So landlords are not prohibited from charging deposits. I think that is quite rest assuring. Deposits may need to be charged for other utility charges as well. As for the second question about the proportionate portion, even if you wrote out a guidelines, it's difficult for you to set out every scenario. For a SDU, for a flat with 3 SDU households with different sizes of families, say a family may use water all the time and another rarely use water, despite an agreement with calculation of water charges based on the number of residents in a household. How do you apportion the water charges? In the end, the water charge may exceed the water bills. How should the landlord make the adjustment? Should they increase the charge for a particular household? This problem did not exist before the amendment bill. I'm not sure how you can come up with the guidelines. I don't know how we can specify the relevant situation. Should we round the number up or down for certain households in order for the water charges not to exceed the water bills? I'm worried that a number of such disputes will arise after passage of the bill. I would like the government to think about how you will formulate the guidelines and let us know about that so that SDU household would not be as worried.
Any response from the administration? We take note of Mr. Chan's comments. We will look into it after the meeting. We'll see how we are going to draft the guideline and we'll report to the committee. Can you provide your preliminary thoughts on how you're going to draft the guidelines? We have to solicit views from relevant associations and bodies. We will take into account the views we got from the public hearing as well. Well, some members have pressed the button to speak for another round. Yes, Mr. Andrew Lam. Thank you, Chair. I want to make a point about the guidelines. For SDUs, it's not practical if you look at the number of tenants of a unit because tenants come and go. So you should stick to the size of the unit when you consider the proportionate portion. My view is that if you want to avoid confusion, you should ensure that this is included in the tenancy agreement. The amount of charges should be based on the size of the unit. As mentioned, we will talk to SDU concerned groups as we draft the guideline. We'll also talk to the estate agent authority so that we can come up with a comprehensive guidelines that can be put into practice. Ms. Doreen Kong. I have a minor comment for the administration and the DOJ. For this Regulation 47, I read Subregulation 1 and 2 in detail. Subregulation 1 is about sale of water and offer for sale water. For Subregulation 2, it elaborates on Subregulation 1. It talks about what it means by selling water. So if a person charges another person for using the water, this amounts to selling water, according to the proposed bill. I think you can interpret very broadly whether a person is selling water if he or she charges another person for using the water. In normal tenancy agreements, well, a landlord may charge his tenant deposits. But after all, we refer them as charges. If we want to avoid confusion, or if we want to avoid loopholes, I think the administration will have to think about how it should draft Subregulations 1 and 2 carefully. You are defining what it means by selling water in Subregulation 2 here. Anything to supplement, Director? I thank Ms. Doreen Kong for the questions. For Subregulation 2, we make it clear that if a person charges another person for using the water, it amounts to selling of water. And Subregulation 4, we elaborate on the part about specified charges. And you have to refer to the water meter as well as the water bill as you charge the specified charges, so we can see the entire procedure through Subregulations 1 to 4 here. However, for Subregulations 4 and 5, well, let's look at the structure of the sentences here. You do not prohibit people from charging the specified charges, but you did not mention not prohibiting people from charging a deposit. If you look at Subregulations 1 to 5 together, well, as a legal practitioner, I understand the worries of Mr. Andrew Lam. This is just my personal view. Anything to add by the administration? Yes, Ms. Ho. It is not our legislative intent to affect what it means by water charges. We just want to make clear the different roles of different parties. Under normal circumstances, the seller is the water authority, and the person who uses the water is the buyer. For landlords, that is what we call registered consumers. They may charge their tenants for water used, and this is considered as a sale of water. So in Subregulation 2, we want to make it clear that the water is not provided by the landlord, but as long as the landlord charges another person for using the water, it will be considered, the landlord will be considered as the seller. So we want to make clear what it means by sale of water. So Against this backdrop, as mentioned by the administration, for sub-regulations 4 and 5, they are consistent with Regulation 46 as well as the schedule to the ordinance. And it is also in line with Section 19 in terms of fees charged by the Water Authority. Chair, sorry, I have a quick question. I don't think the Government Council understands our questions. If we want to make sure that we can proceed with the clause-by-clause examination, can we have the administration provide a written submission on its views on the charging of water fee deposits? Thank you. Next, Mr. Lai Tong Kwok. We're making it look complicated because in sub-regulation 4 you use the term specified charges, and later on you use the word reimbursement. Charges can be interpreted much more broadly than reimbursement, and concerns arise in relation to whether it covers deposits or not. In the latter part of the provision, you make it clear that it should be a reimbursement and that it should be a proportionate portion of the specified charges. Perhaps you can look at whether you should make some small adjustments here to avoid any confusion. Next, Mr. Chen Xiu-hong. I have a technical question about proportionate portion and specified charges. This has to do with proportionate arrangements made by landlords. I've got inquiries. Say, if it is specified in the rental agreement that certain water fee is charged based on the water consumption, and you charge the tenant based on the cubic meters of water used. And if we look at the aggregated sum, it gets to tier 2 of the tariff structure. And there is no way for the landlord to find out who uses more water and who is responsible for the exceeded amount when it gets to tier 2 of the tariff. Well, let me respond to Mr. Chen's question. Currently, well, under the current ordinance or the amended ordinance, we have what we call the specified charges, which is based on the water consumption in terms of cubic meters. And if a landlord overcharges, then he will violate the law. Say it costs 4.1 per cubic meter, and the tenants and all tenants of SDU uses less than 31 cubic meter. And when the landlord charges the tenants, he refers to the water bill, and the aggregated sum would be 6.45. and each tenant would say that it should be some $4 per unit. But from the landlord's perspective, the landlord is not overcharging based on the water bill issued by the water supplies department.
Understood. If each of the subdivided units use a varying amount of water and the aggregated water bills would exceed the tier of water charges each household is using. But the landlords actually pay the water bills in an aggregated sum to the water supplies department. If the water bills is $100, the landlords would pay $100 to the water supplies department. The landlords should not charge more than $100 to the tenants. So how should the landlords apportion the charges? Well, if there is a water meter, then the problem would be solved. What about if there is no water meter? If there is no water meter, then what kind of indicators or standards should we make use of in order to achieve this apportionment principle? As mentioned, we need to look at how we can draft the guidelines better. We've heard some of the comments that we can make reference to from Mr. Lai and Mr. Lam. There are different ways for us to calculate water charges, and we will set that out in the guidelines. If there is no further comment about this part, let's move on. Now we move on to subregulation 678. Subregulation 678 are talking about the penalty. You can refer to page 4 of the marked up copy. We have raised the penalty from level 3 to first conviction to a fine of level 3, and subsequent conviction will be subject to a fine at level 4. As for subregulation 7, it says that the seller can be ordered to repay the buyer any extra money received or charged. And in subregulation 8, we define specified charges, specified rate, and specified user. If there is no further question, I will move on to, well, there are some questions. Please pause. Mr. Lai. Chairman, I have a comment and a question about subregulation 6. It says that anyone commits an offense is liable on a first conviction to a fine at level 3 and on a subsequent conviction to a fine at level 4. I have two questions. First, if the offender is a company, because a company can be a landlord, so will the company be charged? If that company owns 10 units and if there is overcharging in relation to one property unit, then the company is charged. If the company charges different households extra water charges, will they be subject to multiple convictions that is therefore subject to a fine at level 4? Is that your legislative intent? Ms. Ho, please. Thank you for your question. I'm not sure if I fully understand your question. Are you asking if a person or a company overcharge different households for water bills, will they be subject to a fine of level 4? We're talking about convictions, but for subdivided units, we are not connecting the contravention to any particular households. So as far as we understand, when the court is handing down penalty, they will look at whether the person or company is in violation of section 47 bracket 6. So if there were 4 subdivided units in a flat and the landlords overcharge one of the units, and in the course of your investigation, you found out that the landlords overcharge various or all of the household, how would you hand down the penalty for other convictions? Ms. Ho, please. Thank you for your follow-up question. When the offender is sentenced, then the prosecution will initiate charges or prosecution against the other charges. If that person or company is convicted again, then that person or company will be subject to a fine at level 4. If in the course of investigation, the enforcement agencies find out that the landlords overcharge water for all of the SDUs, then the cases will be handled in parallel. If that is a first conviction, then the company or person will be charged a fine of level 3. So that depends on the case. I would also like to ask about Regulation 7. The magistrate may, in addition to imposing a fine, order the seller to repay to the buyer any money received from the buyer. But you use this word may. If that's the case, will the prosecution need to file to the court asking the landlord to repay the money? Should the buyer or that is the tenants apply to the court for the seller to repay the extra money charged? I suggest that you dispense the use of such word may. If the landlords overcharge, then they will have to repay the tenants. That will streamline the repayment, and it shows very clearly or the message that no one should overcharge anyone for water bills. Thank you. Thank you for your question. Let me give you a reference. We have make reference to LTCO 120A/ZZM subsection 6. It says that the magistrate may order the defendant who is convicted to repay the money in excess charged. So as to whether or not we should use the word must or may, the prosecution division gave us some advice. Usually in drafting the bill, we allow the court to have discretion. That is why when we were drafting the bill, we choose to use this word may, so that the magistrate will have a certain discretion to hand down penalty. And we have also made reference to LTCO. You ask if this word will affect the procedures for application of repayment, we believe that this word may will not affect the procedure, but as for details, we will have to consult colleagues from the prosecution department. Under general circumstances, the prosecution may apply for, say, compensation order that is not related to the usage of words. Well, the answer is very clear. We have to ask what the policy intent of this bill is. So as long as you overcharge, you have to repay. So is this the policy intent? Yes. If that's the policy intent of the bill, why should we allow the court to have discretion? You said that similar wordings is adopted in LTCO, but that does not mean that we should copy directly from LTCO in this bill. Because when we are reading the bill, we need to understand your policy intent. I would not make guesswork as to what the policy intent of making use of may in the LTCO, but we are considering the Waterworks regulations. The policy intent of the amendment is to ask the seller to repay the money charged in excess. We need to make sure that the victims will not have to pursue any repayment through the court. And we should not have to consider any application or any legal procedures when we are asking the offenders to repay money. We need to let everyone know that this is a very serious issue. It's only right for anyone who is overcharging to repay. We have thought about this issue, and we discussed this in the panel as well. For different penalties, we need to allow magistrates some kind of discretion. Perhaps DOJ will supplement. Ms. Ho, please. As mentioned, we have consulted the prosecution division. In terms of the use of wording, it may affect other legislations as well. We are clear about the policy intent of this amendment bill, but we have to look at the entirety of the laws of Hong Kong and the views of the prosecution division. The government department also agree that we should allow discretion for the part of the court and the magistrate. The magistrate may order the seller to repay the buyer. Let me supplement. I disagree with what the DOJ said, because repayment is not a kind of penalty. The court is not asking the seller to repay 70 cents when they have overcharged 50 cents, for example. We're asking the seller to repay the money charged in excess. This is a policy. There is no room for discretion here. I think that your message is very clear. You note the comment, right? We will be submitting a written reply. Next, Mr. Andrew Lam. Thank you. Mr. Lai has asked multiple questions in relation to Subregulation 6. I would like to clarify. a person includes a person, a company, or a unit with multiple landlords or owners. If my understanding is correct, then I would like to follow up on government's reply to Mr. Lai's question. If a person contravened the regulation in a unit, and if that person owns an other unit with other people, would the scenario you mentioned just now apply? Will that person be subject to a fine at level 4?
好，老師。
Yes, Ms. Ho. I thank Mr. Lam for the question. First, let's make it clear that this provision per se does not target landlords. We're just referring to any cases in which a person charges another person for the use of water. So, the administration will gather evidence on a case-by-case basis. Whether a landlord co-owns the unit with another person as he overcharges is not relevant. Let's say the case is established and the provision does not target or does not specify whether it is a single person or an entity. So it could be more than a person that violates the law. Would there be a case where a person contravenes the law for the first time and contravene the law for the second time with another person and gets convicted? Well, this is possible. I think you have to think about fairness here. Let's say a company rents out a unit to a person, and the company has more than one shareholder or more than one owner of units. Say a shareholder knows that another shareholder of the company contravenes the law. Would that be fair to the other shareholders who contravene the law without knowing that another shareholder of the same company had contravened the law? We'll look into it after the meeting. Can we carry on with the clause-by-clause examination? Now we come to clause 5, and there are the newly added regulations 47A, B, C, and D. For 47A, it provides that the Water Authority can ask for relevant information from relevant party. For sub-regulation 3, it says that if the person who does not comply with the sub-regulation 1 may be fined at level 3. If the person does not provide the information within the set time frame, then a further fine of $1,000 for each day will be incurred, during which the offense continues. For sub-regulation 4A and B, when the law enforcement party asks for the information, the relevant party will have to pass the information to the law enforcement agency. And the specified persons here refer to public officers, magistrates, and so on. The public officer here refers to the public officer mentioned in sub-regulation 4A and B. For relevant person, there is a definition. It refers to landlord, a person who charges a water fee, a tenant or former tenant, an agent or a former agent. They are considered as relevant person in the bill. or invoice, bill, demand, note, payment record, etc., they're all considered as reference document. For Regulation 47B, it's about providing false or misleading information or documents. Sorry, Director, I see that concerning 47A, a number of members have pressed the button to speak. It's now 6:20. I suggest that we finish 47A before we end the meeting. And for the rest of the bill, we can follow up in the next meeting. The meeting is scheduled to end at 6:30. Perhaps we can extend the meeting for 15 minutes. 4 minutes for each member. Mr. Andrew Lam. I have a small comment for 47A, Sub-Regulation 3. I believe that this penalty applies when a person contravenes Sub-Regulation 1 and 2, right? As to when a person should provide the relevant information asked for, I think it's clear. As to the way and form in which the information or reference document is to be provided, I think it's not very clear. It can be provided in electronic form, right? Let's say the person who is asked to provide the information can not provide the information in the way and form asked for, then the person will contravene Sub-Regulation 3. Then I believe the administration will have to explain what it means by the way and form in which the information is to be provided. For Sub-Regulation 5, it's not a question about wording. I just see that in the English version, the order of the subsections here differ from that of the Chinese version. That's all. On the point about the way and form in which the information should be provided, normally when we gather evidence, we ask the person concerned to provide paper form of the document or information. We may also ask the person concerned to make a witness statement in our office. That's why we are referring it as way and form. Next, Mr. Chen Xiu-hong. For 47A, in relation to Water Authority supplementary powers, this is a crucial part of this bill. I agree that the Water Authority should be given the powers to obtain the relevant information and document it needs. However, we have to be careful that we are not giving too much power to the Water Authority. Currently, under the proposed bill, it says here 47A is about Water Authority supplementary powers for Regulation 47. It says here that the Water Authority may by notice request any relevant person of any premises to provide any information relating to or any reference document. It says in Regulation 5 clearly what it means by reference document. So this is all clear. However, it says here that the person may be asked to provide any information. It says here that you are going to request people to provide information for the purposes of Regulation 47. Well, would the Water Authority be given power to ask for information that's not relevant to water bill or water payment? And for Sub-Regulation 2, we don't see the word any reference document, unlike in subregulation 1. The relevant person may have to provide any reference document. So I see that subregulation 2 is clearer in this sense. I wonder that if you include the word any in subregulation 1, would you be given the water authority power to ask for any information? Also, we're concerned that in the course of gathering evidence, for the purposes of Regulation 47, the Water Authority may pass the information to specified persons if the information includes documents concerning water bill, gas bill, and liquefied petroleum gas consumption. What if the tenant refuses to provide information about other utility charges to you? Well, with 47A here, it's not allowed that the tenant can refuse to provide this information. I'm just wondering if there is a limit to the powers given to the Water Authority under 47A. Thank you, Chair. Ms. Ho? I thank Mr. Chen for the question. In terms of whether the Water Authority would be given too much power under the Public Power Act, there is certain limitation to the power that the authority is given. We have to make sure that the authority is reasonable as it enforces the law. By reasonable, it means that the power given should not exceed the power that it needs. So there is certain protection offered by the administrative law. From the perspective of interpreting the provision, well, any reference document and any information, they are put together here in one sentence. We want to protect the privacy of the public. So when we look at these two phrases here, we understand that the information and reference document referred to here, they are interrelated. And when the court handles the case, it would only refer to information that is relevant to the work of the Water Authority. It is only under this context that Water Authority can exercise its power to ask for information. Mr. Chan's question is that under 47A, it says the Water Authority can request any person to provide information for the purposes of Regulation 47. Same for Subregulation 4. Say a complainant or a member of the general public may take the initiative to offer information to the Water Authority. And the information that we are referring to here is not limited to the information requested for the purposes of Regulation 47 as set out here.
Ms. Khan, I have some questions. In Section 47A, it says that relevant person need to provide information. Under 47A, subregulation 5, there is a definition of relevant person, which is rather broad, including agent in bracket F. As far as I understand, the scope can be very broad. When the landlord passes away, the executor of their authority can be an agent, and the secretary of the landlord can also be the agent. Under LTCO in 120AAZW, Rating Evaluation Department can only ask the landlords and tenants to provide reference documents. But under 47A, we ask many parties to submit information. I'm not objecting to this, but I think that the government should do publicity because this is clearly different from the LTCO that we have. Because when we're talking about SDU, a lot of people are involved. So all these relevant persons, if they fail to submit information, they will be violating Section 47A. I would like to point out another thing in relation to 47A bracket 3. If anyone fails to submit information, they will be subject to a fine of level 3 and a further fine of $1,000 for each day during which the offense continues. As for 120AAZW and 120AV, RVD can ask the landlords and tenants to submit information and documents. If they fail to do so, they will be subject to imprisonment of 3 months. But under 47A, the offenders will only be subject to a fine. I'm not objecting to this. As we discussed previously, we need to let the public know that there is such a difference. If the person is charged with Waterworks of related offenses, that person will only be fined. But if that person is charged with LTCO related offenses, that person may be sentenced to imprisonment. We need to know the difference. As for subregulation 4, the Waterworks or Water Authority can disclose information to RVD or relevant departments for enforcement. But unless the Water Authority does not initiate prosecution under 47A, they will not be disclosing information to RVD because we cannot violate this principle of double jeopardy. I just want to point out that this subregulation is not as useful. I have a comment on subregulation 5A2. Can we set out any consumption of water in the English version? Because consumption is rather broad in terms of definition, because we're talking about waters here. Can we put of water after the word consumption? Thank you, Ms. Khan, for your comment. We want to broaden the scope of the laws to protect subdivided unit tenants. Apart from overcharging of water bills, under Section 7 of the LTCO or Cap 7 of LTCO, if other violations is involved, then the relevant information should be disclosed to RVD. What about the point about consumption of water? Under Waterworks ordinance, we have defined the word of consumption, which says that it relies to the supplies of water. So that's already defined. I would like to ask about Section 47A, bracket 1. It says that for the purpose of Regulation 47, the Water Authority may, by notice, request any person, and so on. Notice may be in writing or orally, or done orally. But the Chinese translation or the Chinese version is different. So are you asking any relevant person to submit notice in a written form or in an oral form? In Section 37 of the Waterworks Ordinance, we define the word notice. Sorry, it's Section 38. It says that all notice shall be in writing. So that's already been defined that, well, all notice should be done in writing. As for subregulation 2, as for 2A, in the English version it says that the time, but in the Chinese version it says any time. So is the date included, or are we talking about the hours of certain date? Because this will affect the enforcement. Because if that person does not submit a notice or information before the deadline, then that person will be prosecuted. We will set out a date on which the person has to submit information. So by date we mean by the about 11:59 of that day, 11:59 p.m. of that date. As for subregulation 2B, it says the way and form. As the government department has said, a statement may be involved. As you all know, statement is usually made in a written form unless you do video recording. So what about telephone calls? Will a call constitute evidence or reference documents? The person may think or argue that you have not set out the form clearly in the notice. Then they will not be submitting information in the way that you want. Well, because we will set out in the notice that the way in which the information should be provided. As mentioned, we will invite the person to, on a certain date and hours, to come to the Water Supplies Department office to make a written statement. So that's already, that will be set out in the notice. Thank you. As for subregulation 3, in the English version, line 4, in the case of a continuing offense, I think that this is rather confusing. So is it the case that whenever there is violation of section 47A bracket 1, there will be continuing offense? Because if you make use of the words in the case of, then some people would think that some is the case and some is not the case. I understand that you copied from the previous provisions because these words in the case of appear in section 37. But I think that you should not use these words in the case of here because the scope of this provision is narrower. Thank you, Mr. Lai, for your question. As mentioned, under subregulation 3, a person who fails to comply with the request in the way and form specified, then that person will be violating subregulation 1. So that will be the case when the offense is not a continuing offense. If that person fails or submit the documents a day after the deadline, we need to be broad in terms of drafting of the bill. I understand that the policy intent of the department that a fine of level 3 is the baseline. When a person violates subregulation 1, then that person can be fined at a level 3. If the person violates the offense or say submit the documents 10 days after the deadline, then that person will be subject to a fine of $1,000 for each day during which he fails to submit the documents. Chairman, I think that we need to clarify what it means by continuing offense. There is not such a definition in the bill. I tried to look it up in Cap 1 of the laws of Hong Kong. I could not find it there. Perhaps some kind of authority is involved. We need to clarify what it means by continuing offense, because the government said just now that if a person submit documents 10 days after the deadline, then that person will be subject to a fine of level 3 and $1,000 times 10. If we do not have a definition for continuing offense with these additional words of in the case of before that, that will cause confusion. I would like to think about that after the meeting. Perhaps we should clarify it here, because a further fine of $1,000 for a continual offense is quite serious. I agree with the deterrent effect, but I don't want any disputes to arise. For example, you can say that if you violate the request, then that will constitute a continuing offense. But by the way you put it, that will give rise to disputes and arguments, and that will affect the deterrent effect intended. Thank you. Any response? So you will go back to and think about that. So after Mr. Chen has put his question, then we will conclude the meeting. In the next meeting, we will allow the government to reply to the questions put in this meeting, and then we will proceed to 47B. Mr. Chen Xiu-hong, I would like to ask about 47A subregulation 2. In the English version, subregulation 2 bracket A, it says any regulation or information. So are we referring to the information as set out in subregulation 1? Otherwise, perhaps we should use reference document or any information or reference document or the document as specified in subregulation 1. There is difference between the Chinese and English versions. Thank you for your question. Some members ask about the use of articles in the English and Chinese version. Because information is uncountable, so whenever we come across this word, we would add an any before that. In the Chinese version, because we don't use article in Chinese, so we have a greater flexibility in the use of words. Mr. Chen is correct. Subregulation 1 and 2 are interrelated. So we try to take the middle ground. If you read from 1 to 2, then you will understand that information refers to information as set out in the notice. That is why we have not further clarified it. So that concludes our discussion. I would like to thank members for identifying various problems, and the government has given some reply, but I think that we need to give time for the DOJ and the Water Supplies Department to think about the issues. If amendment is needed, please go ahead with it. I will work out the meeting time with the Secretariat for the next meeting because some issues is involved. So that concludes our meeting. Thank you for staying in this meeting on this Friday. Thank you. The meeting is adjourned.